Supreme Court Decision, Bondi versus Vanderstok, 23-852. March 26, 2025. Background. This case addresses the question of whether the Gun Control Act of 1968, GCA, which requires firearm manufacturers, importers, and dealers to obtain licenses, conduct background checks, maintain sales records, and serialize firearms, extends its regulations to so-called weapon parts kits and incomplete frames or receivers. These items have recently grown popular as they allow purchasers to easily assemble firearms at home, creating a significant rise in untraceable firearms known as ghost guns. In response to the increase in ghost guns used in crimes, the Bureau of Alcohol, Tobacco, Firearms and Explosives, ATF, issued a new rule in 2022. This rule clarified that certain weapon parts, kits, and unfinished frames or receivers fell within the GCA's definition of firearms. Gun manufacturers challenged this rule, arguing that the ATF exceeded its statutory authority under the GCA. The Fifth Circuit Court of Appeals sided with the manufacturers, holding that the ATF's interpretation went beyond the statutory definition. Supreme Court Decision. The Supreme Court, in an opinion delivered by Justice Gorsuch, reversed the Fifth Circuit, ruling that ATF's interpretation of the Gun Control Act is valid on its face. The key holdings were weapon parts kits, Section 921A3A. The GCA defines a firearm as any weapon that can expel a projectile by an explosive action, is designed to do so, or can be readily converted to do so. The court ruled that at least some weapon parts kits, specifically referencing Polymer 80's Buy, Build, Shoot kit, clearly qualify as firearms under this definition. The Polymer 80 kit was highlighted as an example because it can be assembled in approximately 20 minutes using common tools. This ease of assembly makes it readily convertible to an operable firearm. The court noted that although not all kits would meet this standard, the existence of kits that clearly do defeats a facial challenge to the rule, incomplete frames or receivers, Section 921A3B. The court held that the GCA also reaches at least some unfinished frames and receivers, such as Polymer 80's incomplete Glock-style frame. Justice Gorsuch pointed out that the terms frame and receiver, like weapon, are artifact nouns that may describe objects not yet fully assembled. The court observed that Congress has previously required serialization of incomplete or unconventional frames or receivers in other contexts, implying Congress intended to regulate certain unfinished items. Further, ATF has long interpreted these terms to cover partially complete frames or receivers, a stance not previously contested by plaintiffs. Thus, a facial challenge fails. Arguments about textual differences and consequences. Plaintiffs argued subsections A and B differ linguistically, and that interpreting them broadly could create unintended consequences under the National Firearms Act (NFA), potentially classifying popular rifles like AR-15s as machine guns. The court rejected these concerns, noting the government expressly disavowed such an interpretation. Additionally, it clarified that its analysis of the GCA does not imply similar interpretations would extend automatically to the NFA. Rule of lenity and constitutional avoidance. The plaintiffs requested invoking the rule of lenity or constitutional avoidance principles to resolve ambiguities in their favor. The court found these principles inapplicable since it determined that the statute's text, context, and structure were clear enough to resolve this dispute. Ambiguities that might arise in future cases did not affect this decision. Outcome: the Supreme Court reversed the Fifth Circuit's decision and upheld ATF's regulation as facially consistent with the Gun Control Act. The case was remanded to the lower courts for further proceedings consistent with this ruling. Vote breakdown: majority. Justice Gorsuch, joined by Chief Justice Roberts. Justices Sotomayor, Kagan, Kavanaugh, Barrett, and Jackson. Concurrences, filed separately by Justices Sotomayor, Kavanaugh, and Jackson. Dissents. Justices Thomas and Alito each wrote dissenting opinions. Subscribe for more!